2, 1. Perfect. And we're live. Yeah, so thank you very much for joining today. This is the last one of the year in terms of the local business champions. I'd first and foremost like to thank John and the team for all the hard work that goes on behind the scenes this year, because we've run a good series of these now since, what was it, late July time, I think it was, John? Early August we kicked off. Time's flown by, right? And there's been many different topics covered, many different guest speakers. So yeah, thank you very much for that. As always, if you have any questions, please share them in the chat, and likewise, we'll try to make sure those questions are answered during the session. We've got 2 speakers today, which is awesome. So we've got Dave, who will cover sort of the second half, which is around changes to data protection and GDPR and what that means to everybody around the Brexit discussions. And to kick off though, we've got Claire, who's an IA director at STOBS, Intangible Asset Management. And she's really going to be talking today about trademark laws, changes in and around brands, what that means post-Brexit, and at the same time as well, touch on a small bit of patents. Is that right, Claire?
Yeah, just a touch.
Just a touch.
Just a touch.
Awesome. So with that, yeah, and if anybody else would like to share their contact details in the chat, please do so. And with that, Claire, I shall hand over to you to share your screen and kick off your presentation.
Thank you. Right, just bear with me while I put the presentation up. Perfect.
Fantastic.
Great. So thank you everyone for joining this afternoon. I am going to talk to you a bit about Brexit and the effect that it's going to have on intellectual property. For those of you who don't know me on the call, I am a senior trademark attorney at STOBS. I'm also one of the directors, and I've been in the IP field since around 2007, and I've got a previous background in retail management. So I've sort of throughout my career have kind of lived brands, as it were. So what I'm going to try and do is, obviously this isn't the most riveting of topics, but I've got some slides, and hopefully what we discuss today will be interesting for you all. So as we know, the UK left the EU on the 1st of Feb, and the transitional period is due to expire at the end of December. So what this presentation really is going to focus on is what will happen to my IP that I own in Europe. Have I got any disputes that are pending and will still be pending? What will happen to those? And a little bit about customs declarations, how they will be affected, what you'll need to do if you've got customs recordals, and domain ownership, because there are some changes around some of the domain extensions. So we're going to look at registered EU trademarks and applications and the differences with how they're going to be treated, the same with designs. A little bit about unregistered designs, because there's a little bit of disparity between the EU system and the UK system. Representation, so who can represent you moving forwards, and now we're not part of the EU. A little bit about patents and copyrights, renewals, licenses and security interests, assignments and agreements. So just sort of thought prompters, I guess, for what you need to be thinking about as we're getting closer to the deadline. So looking at trademarks first, so the trademarks that currently cover the UK, so we have national UK trademarks, and they are filed with the UK office. There won't be any change to those in how they operate. The other way currently, which you can protect your trademark in the EU, is through the European trademark, and that covers currently the 28 member states of the EU. And that's filed through the European Intellectual Property Office, which is based in Spain. Over the years, we've had countries accede into the EU, so we've had transitional provisions for new jurisdictions that have entered. This will obviously be unique in the fact we're leaving, so there'll be changes from us putting out and how that will affect the rights. And then the other way you can protect your trademarks in the UK currently are through the international trademark system. So for those of you who aren't familiar with this, it is kind of like a management system for your international trademark. So you file one application, and then you can designate lots of territories which form part of the Madrid Agreement. With your international application, you can kind of manage all of the renewal deadlines at the same time. You file one application. It often works out cheaper than filing national applications. So it's a really good tool. There are some downsides to the system, as there are with something which is kind of treated in a unitary way, but you know, it's a system we definitely recommend for our clients if they're looking at filing internationally. So those are the ways you can protect your trademark moving forward. So what will happen to my existing EU trademarks after Brexit? So I've got my little sheep analogy here. For those of you who remember Dolly the sheep, she is a clone. So we have Dolly with her little UK rights hat on the side. So with EU trademarks, after the on the 1st of January, as we will no longer be part of the EU and the transitional period is ending, the UK will create a cloned right of the existing EU TM. So this will be identical in every way to your registered European trademark, same mark content, the goods and services, same owner. The UK are in the process of creating these rights, and we are scurrying away behind the scenes at Stobbs getting these rights onto our system in preparation for Brexit, and they will subsist automatically as long as you've got a registration. So the way that they're going to be managed is that they will have the same trademark number as their EU counterparts, but they will have a 9 in front of them if it was a nationally filed EU mark, or it will have an 8 in front of it if it came from the international system. There won't be any registration certificates, and you won't get a formal notification that this will happen, but this right will exist. So the point of this is to try and prevent you losing any rights that you already have. Priority claims which are recorded against the EU trademark will also be inherited by the clone, and a priority claim, for those of you who aren't aware of what that is whereby you first file a trademark for certain goods and services. So the first time you've ever filed it. For the next 6 months, you can keep the original application date, but have that for any of the jurisdictions you file worldwide. So say if you file in the States first, that's your home base on the 1st of Jan 2015, and then you filed in the UK 3 months later, in the EU 3 months later, you could claim that earlier filing date. So it's only for the first time you file a trademark for certain goods and services, but it's a good system. So where you've got priority dates, and whilst it's only 6 months, sometimes they make all the difference when you're looking at cascades of rights, you can keep that date on the corresponding UK. Seniority claims, that is where an owner, in this case, it will be UK seniority claims which are affected. So the European trademark system has been in existence since 1994, I believe, off the top of my head. And obviously trademarks have been around a lot longer than that. So for example, if you had a UK trademark application or registration which you've owned since say 1975, and you filed an EU trademark, you will then have, previously you will have had concurrent rights. So you would have had the EU TM, which covered the UK, and also your existing UK rights. So what the seniority system allowed you to do was stop renewing your UK right, but you were allowed to keep the earlier date in relation to the UK, and that was noted on your EU TM. So what will have happened over the years is people will have let their UK rights go, and obviously the UK office didn't want people with these earlier rights, seniority rights, to lose out. So they're going to also be recorded against the new UK trademarks to make sure that, you know, people don't lose their existing earlier rights.
Can I just ask a quick question on that topic? So if you've already filed with the European Union for a trademark, you will automatically inherit the UK trademark off the back of that. Is that correct?
Assuming that it's registered, yes. So as long as you've got your registration confirmed and you've got your registration certificate, that you will automatically get the corresponding UK rights.
And in the opposite direction, so we've, as a business, got UK trademarks in play already.
Yeah.
We would have to apply now to the EU TM for trademarks there, or would...
Exactly. So if you wanted to cover outside the UK, you could either file the EUTM, which obviously now effectively it's going to cover everywhere but the UK, or you could file nationally. So you could, if you're only interested in France and Germany, you could just file there. But the reason the EU trademark system is so good is, you know, it's very cost effective. In a lot of cases, it's pretty much, you know, the cost of filing in 2 jurisdictions to get coverage everywhere. There might be reasons why you don't do that. Like there might be earlier rights in, say, you know, I don't know, Italy, and you want to avoid that. But where you're clear, the EUTM is the most cost effective option.
So realistically, we should move our trademarks to EUTMs as well as UK.
Yeah, so if Europe is important to you and you're operating there, or you're shipping there, or you have an interest in there moving forward, particularly now because a UK right after the 1st of January won't be effective against an EUTM, you could knock out the EUTM based on UK rights previously, then yes, it would make sense to think about European protection as well.
Awesome, thank you very much.
No worries. So in terms of the clone process, you can opt out. We're not recommending that you do that because it's more admin, unless there's a particular agreement that you've signed that you wouldn't own a national UK right, for example. There's no harm in keeping those until, you know, you need to renew them, and then I talk a little bit about renewals later, and then make a decision whether you want to keep them. So registrations, you know, all good. You'll automatically get a registration. For applications, unfortunately, these aren't automatically going to be transferred onto the UK register. So if you have a pending EU application at the 31st of December, you won't get a UK right automatically. So you will need to file a new UK application. What the UK are doing, they're giving you 9 months, so you don't have to, it's not one of those things you have to do it immediately in January when everyone's got loads of stuff to think about. You've got 9 months, and you do get to keep the original filing date of the EU application, which is important because particularly for some of my clients, we've had disputes going on, you know, 2, 3, 10 years in some cases, and their rights won't automatically transfer onto the UK register because they're not registered yet. The downside of this obviously is you're going to have to pay new application fees, whereas if it was registered, you'd get a free right automatically. And I think this is trying to weed out basically people who genuinely are interested in the UK market insofar as they can. From STOB's perspective, we're just offering our clients, regardless of the number of classes, we'll only charge you for one class. Our fees, obviously, you'll have to pay the the UK fees for each class that you're in, but that's just something to bear in mind. You've got until the 30th of September 2021 in order to file these subsequent applications. If you don't do it by then, it doesn't mean you can't, it just means you won't get the benefit of your earliest filing date. So your rights will only date from, you know, the date afterwards. For most people on this call, I guess UK businesses, it's likely to be the other way around. You've more likely got UKs than EUs, but, you know, particularly for businesses that operate on the continent and haven't had, you know, UKs before, that might be something that they will need to do if they've got pending applications. And then a little bit about designs. So in terms of their protection, so currently we have UK registered designs and UK unregistered design right, which subsists automatically like copyright does, and the European registered designs and unregistered designs as well. Sorry, move my cat. So yes, in terms of the coverage of these, the unregistered community design is the key right, which doesn't have equivalent protection in the UK at the moment. So I'll go on to talk about that in a couple of slides about what changes are going to be in place. But if you look here, there's 4 different rights, as I just identified, which cover the UK and EU. The difference is the UK unregistered design right pretty much doesn't cover surface decoration and methods of construction, which other rights do. So the UK have had to create some additional rights to ensure that we don't lose protection. What we would have been able to get had we been part of the EU, we no longer get as part of the UK. So I'll go through that in a second. But in terms of existing RCDs, it's the same process with trademarks. If you've got an existing registration, that will automatically transfer onto the register. Again, you can opt out, but probably, unless there's a specific reason why you should, you might as well keep it until you need to pay some money on it, which will be when it becomes renewed. Community design applications that are still pending, again, you have to refile them. There's some specific rules about deferment. I won't go into those now, but if you have got a pending design and you've got deferred publication, that might be something you'd want to check with your usual advisor. As I said, the designs protected in the UK, the unregistered design rights are going to change slightly. So where you had an unregistered community design which existed already, say it covered a fabric pattern that you have, what the UK are doing are creating a UK continuing unregistered design. So basically, for the life of that unregistered design you had protection for in the EU, which is maximum 3 years, you'll get that coverage in the UK. And then for anything new, they've created a supplementary unregistered design rights, which is in addition to the UK design right, which basically covers the extra things that the community unregistered design covered that the UK didn't. So again, to put it simply, the UK have created additional rights to make sure that business owners don't lose out on protection that they would have otherwise been able to have as part of being in the EU. Happily for me, as not a patent attorney, basic patent law essentially isn't going to change following Brexit. UK office will still continue to grant patents as they have done. We're still a contracting state as part of the European Patent Convention, which is an international treaty which established the European Patent Office. And UK patent attorneys can continue to still be representing their clients before the EPO as they have done previously. So no real change there. Copyright, similarly, there are some changes, but they're very specific changes, which again wouldn't, on day-to-day, probably wouldn't really affect most businesses, as copyright is a national right anyway. It is harmonised due to international treaties, and some of our law is based on EU framework. But for most things, such as copyright that will subsist in books, films, and music, it will still be protected in the UK and EU because of our participation in these treaties. So there are some changes, and again, if you're affected by those, then obviously have a chat with your usual IP advisor. But for our purposes, there are some changes, but essentially they're not too many. The big talking point in our profession was representation, because the EU very quickly after Brexit said that UK attorneys are no longer able to represent before the European Patent Office, the European Trademark Office, which for me was slightly challenging because I'm a qualified European attorney. So we've that's still the case. There are ways around it, and at Stobbs we've now opened a Spanish office and a German office in order to fulfill the representation requirements that the EU IPO need. And we have cross-qualified solicitors that can represent in Germany and Ireland as well. So in order to make sure that it's going to be business as usual for our clients, we can still offer the same services that we did before. Originally, the UK weren't enforcing an equivalent provision, but there was a lot of consultation with the profession, and they've recently announced that after the 1st of January, any new UK applications that are being filed will need an address for service in the UK. The only exemption will be for the comparable rights, the clones that have been created, and you've got a 3-year grace period on those. So again, as most people on this call will be UK based, that probably won't really affect people, but happily for us, we are still able to represent our clients before the European Trademark Office. Next thing to talk about is renewals. Unfortunately, this means extra expense moving forward, whereby you would only have renewed your European trademark or European design. you will have to renew the clone as well. So next year's renewals for our clients, we've had to budget for renewing a UK as well as renewing an EU. And this is where we've said, you know, this is the point to decide whether you want your UK clone or not. A lot of, you know, clients will have both European trademarks and UK ones as well for different reasons. They might, sometimes it's nice to have a UK registration, particularly if you want to enforce quickly. And we advised our clients when Brexit happened that they should have a corresponding national UK as well, because there will be some, you know, at the time we're anticipating, you know, transition issues and slowness, and, you know, actually if they wanted to bring an infringement action quickly before the, you know, the transition period, they could do it based on a UK that was registered. So you might be in a position where you've got duplicate rights and actually you don't want to maintain all of them. So that's where we will offer, you know, advice to our clients as to what to keep and what to let go in order to kind of streamline costs as much as possible. Licenses and security interests. So as you'll know, a license is, you know, can be granted by the proprietor of a trademark in relation to specific goods or in specific territories. And security interest is basically a legal right. So, you know, a trademark, for example, which has been pledged by the owner to their bank in order to gain a loan, and they use the trademark as security. So these can be recorded on the European register. Not everybody does. There are pros and cons depending whether you're the brand owner or the other side as to whether you would do that. Essentially, for your UK clone, any licenses or security interests that still apply to the clone. They won't automatically be recorded on the register. So if you do want them recorded on the register, then you will need to do that separately. So again, if that affects you, that's something you need to be thinking about, whether you want to record the UK as well. For assignments, if you've assigned your IP to someone else and you haven't recorded it, so it's a two-step process. You need to have a document signed on behalf of the assigner for consideration in order to assign your intellectual property. And then in order to reflect the register, you then need to submit a form to change it. If you've assigned it to someone else and you haven't recorded it yet, the new UK right will be created in the original owner. So then you'll need to submit 2 recordals to change both the EU and the UK as well. So again, that's just something to bear in mind if you're doing an assignment sort of close to the deadline, actually whether it will be recorded. If you have a pending application that's been assigned in the EU after Brexit, either the assigner or the assignee, until it's recorded, have the right to apply for that. So again, that's just something to bear in mind as well. In terms of agreements, we're recommending that you look at any agreements you might have, license agreements, coexistence agreements, just to see whether Brexit will affect any of the terms in there. There might be reasons why you can't own a corresponding UK right, or it might be simply law and jurisdiction. You know, we tend to base most of our agreements on UK law, but there might be a reason why, you know, jurisdiction will be important to change based on the agreement. So that's something we would recommend you do, review any agreements that you have. Disputes is the next thing I want to talk about. So if you've got pending disputes before either the EU or UK offices or the courts, I'll just flick through this quite quickly. Essentially, if you have a registered EU trademark that is under cancellation, so someone's trying to revoke it because they don't think you've been using it, or they had earlier rights and they missed the chance to oppose it when it was an application, the UK clone still will be created. What the UK will do will monitor the EU decision. So if the decision would have affected the UK as well, had we still been part of the EU, they would then cancel the clone as well. Good news is if you're the aggressor, you don't need to file a separate cancellation action on a registration. If you have an opposition before the EU office, so if you have filed an opposition against an EU trademark and you've only based it on UK rights, the EU IPO are just kicking it out. So there will be, the proceedings will be concluded on each side bears their own cost basis. The only positive out of that actually is if you only had a UK right, technically you would be stopping them gaining EU-wide right, you wouldn't have stopped them from converting that into a French national, for example. So, but from the positive side from that, they won't automatically have gained a UK clone because you'll have kept the application pending. So they may file again. If they do, it's important you have a watch service just so you pick up the fact that they filed again, so you can challenge them in the UK. But if you've got there's nothing you need to do. The EU will just write to you and say your proceedings have been concluded. Little thought bubble here is, my wishful thinking, but this is the way the UK will treat ongoing proceedings that are based on European trademarks. Essentially, they're going to carry on those particular proceedings as if we hadn't left. Essentially, because a UK right is being created, it would be a lot of faff to switch it to the UK clone. It has the same effect, so they're going to treat it as if it was on the basis of the previous law. So nothing really to do there. On use and reputation in the UK, quick takeaways from this are that if you have an EU trademark that then becomes a UK clone, your use will still count in the EU up until the 1st of January. So any use after the 1st of January wouldn't be taken into account in any of proceedings. And proceedings usually look at 5 years worth of use. So there will become a point where your EU use won't have been relevant. EU are taking a total opposite approach. As of 1st of January, they won't look at any use in the UK, even though it was still used whilst the UK was part of the EU. Exhaustion. So I've got my exhausted cat here. So exhaustion is where where you have an IP protected good and you place it on the market anywhere in the EEA, or you allow someone else to do it, you then can't prevent movement of these goods within the EEA after first point of putting them on the market within the EEA. After the 1st of January, this won't happen. So if you put it on the UK market, it won't be exhausted in the rest of Europe. So that, again, is something to bear in mind. The UK and EU have both agreed that already exhausted goods, so goods that have already been put on the market in one of the EU territories or the EEA territories, will continue to be exhausted, and there won't be a change in what happens to those goods. In terms of our court service, if we have a court acting as an EU court currently, they will continue to operate as if we were still a member state to complete the case, but any actions will only apply to the clone. And if there are any injunctions that have been granted prior to the 1st of January that were EU-wide injunctions, they will still take effect in the UK. So if there was a previous injunction that's been granted based on an EUTM, that will still have effect in the UK after this date. Lastly, I'm just going to quickly talk about customs declarations and domains. So AFAs, if you don't know what they are, is where you put your IP rights on record with a customs office in an EU member state. It basically acts as an instruction for customs to detain goods which they reasonably believe are infringing your IP rights. They can be patents, trademarks, or designs, a wide variety of rights. So if you have an existing EU AFA granted by UK customs, this will have effect in the UK up until its natural expiry date in 2021. You will then need to file a new UK specific AFA after that date. If you have an AFA granted by another EU member state, this will continue after Brexit to have effect outside of the UK. So it will stop having effect in the UK at that point. So if you filed one in France, for example, it will be effective up until the end of December. You will then need to file a new AFA for the UK. This is fine. Obviously, we're recommending you do that as soon as possible because of delays and what have you. This is fine if you already are an existing UK right holder. If you're not, you will need to wait until your new UK clone has been created. And then obviously you might get a slight gap between the protections. There's no fees for the HMRC AFA either, so that at least is something as well for when you do have to file those moving forward. Lastly, on domains, some domain extensions you will no longer be able to own if you are not an EU national or have a place of business in the EU. So it affects .eu, .bg, which is Bulgaria, .fr, which is France, .hr, which is Croatia, and .it, which is Italy. So if you have one of these domain names, you will need to have an address within the EU to maintain them. If you haven't got one, you won't be able to register them unless you have an address in the EU. In terms of how to manage this, because obviously, you know, there will be some businesses that have .eu domains or want to own these extensions for various reasons. At SOBS, we're offering a local proxy service, so we will have a provider who will provide you with the address and will hold the domains for you. The other thing to do is, if you've got a related EU company or subsidiary, you transfer the ownership to them. There might be some tax implications on that though, so I'd recommend you speak to your accountant regarding that. But, you know, to be clear, it's only .eu, .bg, .fr, .hr and .it that are the extensions affected. So if you've got other domain names like a .es for Spain, there's not a requirement on those. But obviously, if you need any help with any of those things, then, you know, please don't hesitate to contact us, or obviously who you would use normally. And that's a sort of brief whistle-stop tour of the changes that are going to be affecting your IP coverage as of the 1st of January.
Fantastic. Thank you for that, Claire. I mean, how many HR and IT companies in the UK right now are going to require that proxy service? I don't know, but from memory, there's a fair few that have got those domain names in flight. And how you get to Croatia from .hr, I've got no idea.
Yeah.
I'm sure there's a logical reason beneath the surface. So just to sort of summarize, I mean, there's so much to think about and cover off there. If you're a UK organization that today wants to protect your logo and brand names, but you are not doing business in Europe today, but it's something you're thinking about in future, then you'd recommend actually getting some advice about protecting those particular brands and logos. Is that correct?
Definitely. And if it's something that you would be concerned by someone setting up or doing something, you know, similar to what you're doing in a EU territory, then it's definitely worth protecting the brand. One of the positives of the EU system is with the UK, you have to sign to say you have a genuine intention to use when you file an application. There's no need to make that declaration when you file. Obviously, you know, if you've got something in the back of your mind thinking, do you know what, one day Europe will be important to us, then it's certainly worth thinking about and getting a registration in. The one thing to think about is the fact that when are you going to use, or because once a mark has been registered for 5 years, a third party can apply to cancel the registration on the basis of non-use. So that's also something to think about, that if you aren't going to be using it, actually you might want to consider filing again if you do have plans to continue to use. But yeah, it's certainly something you should be thinking about moving forwards.
But use doesn't necessarily mean that you've sold goods under that brand. It could be that you've marketed or advertised or done some kind of public awareness exercise. Is that differentiate, or is that a little bit ambiguous?
Yeah, no, you do need to actually have sold some. In order to support a registration, you need to have created or maintained a market share, is the test really. So you can provide reasons as to why you've not used your trademark. You basically, it's genuine reasons for non-use, but they are, you know, it's very, very difficult to prove that. I mean, even some drug companies haven't been able to support that on the basis their trial hadn't concluded, for example. They obviously, you know, had an intention to use, but they hadn't got to market yet because of the fact that their trial, you know, they needed to go through legislation and what have you. So that's something that you can't really rely on, but ideally you would want to be, you would need to be using in order to support.
Okay, but you've got a bit of a runway to do that from the application.
You've got 5 years from registration, and obviously marks don't register straight away. Usually it's sort of 6 to 9 months to get to registration on average, assuming no one objects, you know, but otherwise it could be. So you know, you could end up having another year or 2 years on top of your 5-year period in order to get going.
Awesome, thank you very much. Has anybody else got any questions for Claire before we move on today? I'm going to go with the 5-second rule on Zoom, which is about as long as it takes for people to come off mute. That's awesome. I really appreciate it, Claire. Thank you very much for your time today. There's lots to think about. There's lots to brands to get their heads wrapped around. It'd be great if you could share your contact details in the chat for anybody that's on the call that does have some specific questions and would like to reach out to Claire separately. And likewise, we'll share the recording because there's a lot of data to go through in those slides. So yeah, really appreciate it. Thank you very much. And with that, Dave, you very quickly queued up your slides. So I'm aware of who you are. I think just to give everybody on the call, so Dave presented a few weeks back around some of the changes that are coming as a result of data protection 2018, GDPR, Brexit, et cetera. And today's really going to cover a bit of a follow-up session and a bit of an update. Now, without putting Dave under too much pressure, this is obviously a moving landscape with conversations going on behind closed doors. So some of this still may change again. Is that right, Dave?
Yeah, absolutely. And, I think, what I'll cover today may be out of date by the end of the day. We just don't know right now in terms of, what's going on behind closed doors. But just to confirm, can you see the slide deck okay?
Yeah, I can see that. It's perfect.
Fantastic. Okay, well, just to kind of introduce myself, I work for Arcflux, and looking at kind of security and data protection needs, obviously with a company that is focused around certainly data subject information, consumer information that we store in CRM and kind of digital advertising experiences. I think it's really important to have your finger in the pulse of how is the data economy being affected by these changes? And the thing that I'll cover really from this session is firstly a quick recap on what we covered last time, just in case you missed that, just to get kind of the 30,000 foot view on the digital economy, some of the waves that are occurring in the market right now. If you do store information in countries outside of the ones where your data subjects sit, the people that you actually store information on. So that will include Brexit, obviously a big impact there that we'll cover, but also Privacy Shield, which is the mechanism by which you can transfer information from the EU to the US. That's also had some disruption in the last couple of months, certainly with that kind of being discounted now as a legitimate means. So the first kind of thing to recap on, and Claire covered it really well earlier on, the timescale, when we're talking about Brexit, if we're looking at the digital economy and the GDPR, which was the big component that forced a lot of companies to really understand the data that they are that they're storing and what purpose that they're collecting and using that information for, looking at how they're being transparent with this information. This was kind of the big milestone back in May 2018. A lot of companies were looking at how do we meet the GDPR, these new laws that were actually brought in to kind of unify, ironically, all of the different member states of the European Union. This having one rule book to follow greatly simplifies doing business with the EU in theory, and obviously the knock-on effect of Brexit is, well, that's one member state down, and another third country, as it's termed, that needs to meet these obligations. So we're in a transition period right now, and we've had many discussions on these sessions around that transition period is really designed for companies to actually have time to change and to update processes. But I think it's been more used as a mechanism by which the government are using to kind of understand and get a better deal for each side of the sea. So very interesting in terms of how things have developed. But if we're looking at specifically the GDPR, This was the most highly lobbied piece of legislation in recent memory for the European Union. There was over 5 years of deliberation around different aspects of data privacy and the rights that consumers and data subjects have to their data. Now, with Brexit specifically, this has highlighted a couple of areas that we might need to rethink and relook at. So the record of processing activities, where do we actually store this information? Where does it go? This is all incredibly important for a company to understand to a degree. So many companies are having to look at, where are we storing data? Also where we're actually linked with other vendors and sub-processors. So ArcFlux is no different to a lot of organizations. We use other technologies to support our own, and it actually has an impact in, how do we contract, how do we deal with those companies, what do the contracts say, and obviously international data transfers. The big claim there, if the UK leaves the EU, then we're no longer part of the EEA. We're a third country when it comes to data protection law. And essentially the impact that we're seeing now is that, firstly, we're going to lose that automatic status we got as being in the EU. So it's no longer deemed a safe destination for EU data, and we have to further legitimize the way that we process data. To keep that that free data flow, we need to get following a further approval called an adequacy status, which we don't have right now. A lot of the challenges that the UK have had around data protection law specifically is with our surveillance laws, being seen as too intrusive for kind of high European standards. It was always a contentious debate when the GDPR was being written. Of course, the UK was one of the big players that contributed to the GDPR, but now it's being held to scrutiny under it. The UK did take this stance to adopt GDPR. So, when Brexit was, looming, it was taken that the UK would just take the GDPR, copy paste, and we've now got the UK Data Protection Act 2018. So, this is a way that we can take a step in the right direction to getting adequacy. But the UK government did take some proposed stances to change certain elements. And one of the big debates right now, and I'll touch on this shortly, but how do we keep and attract businesses to the UK over the EU is one of the big issues that's being debated right now. How do we maintain competitiveness, but not unfairly in the eyes of the EU? Ultimately, a no-deal Brexit will mean that we're not deemed as adequate. So, we do need another mechanism if we are talking, about storing that data in the UK from EU citizens. We need to get some better understanding there. So one of the ways that we covered last time, kind of a Brexit to-do list when it comes to data protection. And I'll stand by the guidance we covered last time. I think you've got you're in a good place as a company if you follow what the Information Commissioner's Office has kind of put out as a good standard to follow through these discussions around Brexit and whether it's a deal or no deal. So firstly, complying with the GDPR, obviously that it's a large piece of legislation. Operationally, it's a big challenge for a lot of organizations. But certainly if your company is complying with the GDPR or it has a roadmap to, then you're going to be in a really good position moving into kind of a Brexit situation. Mapping out those processes, looking at each of the EU to UK data transfers and documenting the purposes is going to go a long way for you to understand, well, if things change, if I'm using Privacy Shield, if it's from EU to US or EU to UK, what does that look like? If you have that mapped out, it's much easier to understand what is it that we need to change? What is it that we need to be more transparent about when we're collecting this information? standard contractual clauses where we can't leverage international law or some sort of standard that is predefined, like you know, a privacy shield or adequacy, then making sure that you have this written into contracts so that you can leverage that in terms of what's been agreed with the third parties and the data subjects that you're working with. Reviewing those existing contracts. So I think if you look back at any contract that is over a year old, you know, there may be some wording that is immediately out of date, you know, come the 1st of January 2021. Update your privacy policy. I think this is like the window to the world in terms of what is it that you're doing with people's information. If you are talking to individuals and you're looking to sign them up through your website, or you're selling services, you know, the privacy policy is something that you can really invest in, and it gives people a good feeling about, you know, how well are you looking after my data as a company that is charged with looking after it. So those are kind of the GDPR type issues that we covered. In a similar vein, Privacy Shield is the agreement between the EU and the United States. So it legitimizes transfers to the US, and obviously as a big digital player, you know, there were significant issues very recently where Privacy Shield was invalidated, which basically means that you can't leverage that legitimately as a means to transfer data to the United States. And this is happened before. So anyone that remembers Safe Harbor, similar thing happened back in 2014 where that was invalidated. And the reason it gets invalidated is, again, because of the security services in countries. So the US, for example, having you know, maybe too much influence on companies in the US, for example, being able to exfiltrate data from these systems often doesn't sit well with European standards. So this is really kind of what the you know, the invalidation of these standards and agreements of kind of forced on this particular framework. So in a very similar way, you know, Privacy Shield as a to-do list we covered last time, you know, it was still being debated, although it's been validated. The European Union didn't have any alternative solutions for what companies should use instead of Privacy Shield. So a lot of companies went for this option of, well, we'll just do nothing and see, you know, you can't just stop overnight based on one judgment, the fact that you can no longer send information to the US. But, you know, adding this to your standard contractual clause, as well as kind of the you know, the Brexit wording, you might need to do something similar for your US transfers. Making sure that you have technical technical aspects lined up, like encryption and security by design, so you can actually almost trump some of these issues before they occur. If you can't read it in the US, then it's unlikely security services in the US could read it as well. So there's certain aspects that you could deliver there. You know, one of my favorite ways is to have a reputation with your consumer base, your customers, that you are very transparent about what it is that you're doing and how you protect those data subjects. And I think this is something that is widely overlooked by a lot of organizations. It's something that you can really differentiate against your competitors in the digital marketplace. Privacy Shield may return, so, you know, it's being worked on right now, but I suspect there'll be a version 3 of this kind of digital kind of ecosystem as an update, and it'll be interesting to see how that differs and whether it will be robust against you know, certain other kind of cases against it in the future. So really wanted to cover a couple of updates now. So, I mean, I joked, and also Ollie earlier on, you know, with Brexit updates, I think this could well be out of date by the time I finish this session today. But, you know, one of the things that you can look to is, well, what's happening in the news right now? And I'm sure, you know, there's people on the call right now that would be much more kind of au fait with the latest today. But certainly, if we look at some of the outstanding negotiation points, I think it's quite interesting as to where we are right now. It doesn't relate necessarily to digital economies, but, you know, phishing, big issue here that is being trying to resolve. You know, EU trawlers currently catch 20 or 60% of the total tonnage of fish in British waters. So, you know, it's a big discussion point right here around UK sovereignty. You know, having this level playing field, I think this is very core to the data protection discussion. So, you know, with the UK leaving the EU, you know, they're very careful not to have the UK have too much of a competitive advantage by that being the case. So, you know, having a lower standard of data protection law, for example, is a big fear for you know, the member states in this example. So having this race to the bottom on social, environmental and other standards is seen as crucial as the terminology I use there. But, you know, holding the UK to high standards as the EU is really key to making sure that in the future it doesn't become kind of a weird kind of dystopian place to do business that ultimately harms EU citizens. Resolving disputes, and Claire covered this as well, you know, you know, when things do go wrong, when international law does need to be acted on, you know, the EU wants to make sure that there's a robust system in place. That means that you know, there are consequences. You can't just break international law or break the agreements that have been set up without subsequent impact to the country. And, you know, what stands out about these being the main kind of negotiation points right now, for me, from a digital economy's perspective, is that, you know, data adequacy and data protection law is not an outstanding negotiation point. And the reason that this is the case is that it's more than likely, because this isn't a sticking point, that the UK will get some kind of adequacy status similar to Andorra, Argentina, Guernsey, Isle of Man, these countries that have adequacy in the eyes of the EU, which basically says, we're happy that you've got a law in place that is more or less similar to what we've got in the EU. We're happy for you to be a safe country to store data on behalf of our EU data subjects. So I think that is a positive. Obviously, we've still got a long way to go in the next short few days around what that looks like. From a privacy shield standpoint, I won't go into too much detail here, but certainly there's been some updates here. And the EDPB, or the European Data Protection Board, they kind of advise the member states on, you know, how do you follow the law? How do we want you to make sure that data is safely transferred? And they've kind of given a bit of supplementary information and more or less kind of what the ICO was saying, you know, make sure that you have proper technical measures in place. Store your customer data subject information in a very similar place to where the data subjects are, for example, is a really good way to make sure that you're keeping up with the law. Update your contracts, you know, be transparent as you can. With all three of these categories of measures, you know, they have in common the aim to reduce that potential level of access in absence of controls in that jurisdiction. So essentially, you know, if you follow these areas, it's going to help you locally store that information. I covered this last time, but, you know, the impact of a no deal in this scenario, and when it comes to data transfers, if we're going from the UK to the EU, no additional safeguards are required. From the EU to the UK, you know, something else may be required in the absence of an adequacy status. We may need to look at, you know, standard contractual clauses, BCRs, or binding corporate rules, something like this that would be legitimizing that data. If we look at kind of how this would look under, you know, a deal, you know, things are greatly improved. You know, if we've got an adequacy status, then there's no additional safeguards involved in these data transfers. So, you know, a couple of things there just to bear in mind. I think we're a long way from being 100% clear, but certainly gives you a bit of insight as to what are some of the issues being debated, and, you know, how the data economy fits in with this. And I'll finish up with, you know, quickly, like how we at Artflux have kind of looked at this. Essentially, by having flexible deployment options, we're able to give customers choice about where their data resides. And I think this is quite important. It's a good option that our customers and their data subjects are going to be really thankful for, is that you can choose where that data exists. And if you want to swap it to jurisdictions, then you can. Having that flexibility can really help. Certainly when you're moving data, through a contract. The other thing that I'll highlight is that we are running a free workshop where we can jump on a 20-minute Zoom session with you and help you understand where is your customer data, where are your data subjects located in your various digital systems, and give you a report based on this. What do you need to be aware of? Where do you need to kind of update your policies, the information that you're messaging out when people sign up for your services, etc. So if you are interested, there is a hyperlink here, and we'll pop that in the chat and also in the follow-up. But that might be something that you can use as a kind of stepping stone to understand, what does that digital economy look like to us for our data subjects. And with that, and I know that we're very, very time conscious right now, but with 3 minutes to go, hopefully not too many long questions for me, certainly not on Brexit and what's happened today. Yeah, thank you very much for taking that. But any questions from the room?
So Dave, just really quickly on that. So if anybody's interested in where their data is currently residing with regards to third-party products, and we're all very well aware that sometimes you sign up for SaaS-based platforms to do things such as digital marketing being one of the primaries, and actually where the data resides becomes a complete anomaly. You don't know. So that's really what that workshop's aimed at, is to help you understand where your data currently exists in the cloud. And the offshoot of that is at least it gives you a bit of a framework to start thinking about in terms of your own guidelines and framework around your own privacy and contracts. With that, is there any questions for Dave? Awesome. I'm going to go with the 5-second Zoom rule again. Thank you very much indeed, Dave.
Rule here.
Yeah, well, it seems to stick. Otherwise, I sit there on silence for 30 seconds. Yeah, if anybody's interested in that workshop, please just sign up using that link, and a member of our team will basically join a call with you and just walk through what you have and help you kind of disseminate out where the data resides. John, it's 1 minute to 5. Everybody's still on the call, which seems to be an ongoing theme with the local business champions and has been this year. It's been a fantastic series. It's going to continue into the new year, if I'm correct. I'm not being too presumptuous, right?
Yes, we are. I think it's the 14th of January we're going to be resuming, Ollie, and we'll be obviously communicating the various topics we're going to cover from that time on. And I think, as David said, we don't quite know what they're going to be at the moment, but we will be dealing with the issues that inevitably we will need to look at, and people will need to know more about come January 21. And we'll continue to make sure that we provide the information that people need in all the different aspects. So thank in particular to Claire. I really appreciate that, and it is very detailed and of great concern to some people, and it's really good, and thanks a lot. And we will be obviously sending the slides around so people have got that information. And Dave as well, a really good update, and we very much appreciate you being involved again, and thanks for again your information, and we clearly will circulate that as well. And I know that both Claire and Dave will be pleased to hear from anybody if they would want any further assistance in any aspect of that which they've covered. Other than that, Ollie, I'll just say I wish everybody all the best through the Christmas season, and whatever happens, we very much hope that they will enjoy themselves, albeit that I think we all know that Christmas is going to be slightly different for us all this year than we're used to. But nevertheless, it is a family time, and hopefully we can all rest and enjoy it, and be refreshed, ready to meet the inevitable challenges of 2021. So that's thank you from me anyway. Back to you, Ollie.
That's awesome. And if there was ever an excuse to have an extra glass of sherry or an extra mince pie. I think we've all learned that. So that's awesome. Yeah, thank you again to Dave. Thank you very much again, Claire. It was awesome to meet you both. Well, not Dave. I've known you for a long time. Yeah, hopefully this series has been useful. It's been a real pleasure to host this series. I've learned an awful lot of amazing things since August time this year. So thank you very much. Anything else for anybody to know from the chamber before we wrap up for Christmas, John? Is there anything else that people need to think about attending potentially?
No, it's just to everybody, you know, please take care and look after yourselves, stay healthy. And in the words, of course, of Captain Sir Tom, tomorrow will be a better day.
That's awesome. Thank you very much. Thanks for attending. Take care. Have a good rest of your day. Thank you.
Thank you. Bye.
Bye-bye.